Hello, this is Civil Liberties and Civil Rights, Section B lecture. Our prioritized standards, Government Civics 25. Objectively, you'll be able to evaluate the balance between due process protections and government restrictions against it. Now, the Fourth Amendment states that police cannot search for evidence or to seize either evidence or persons, meaning arrest people, without a proper warrant obtained with probable cause. Now, I should point out only a judge can determine if the standard of probable cause is actually met or not, but it is more specific than other things. Like if you have no information, you can't search. If you have a hunch, you have a feeling, they probably do, that's not enough. Reasonable suspicion, that's also not enough. If you feel like you have reasonable grounds, that's also not enough. You have to have probable cause, which denotes even more likelihood that there is reason to issue that search warrant. Now, in Mapp versus Ohio of 1961, in a 6-3 decision, the exclusionary rule was created, stating evidence obtained by illegal searches and seizures was inadmissible in federal and state courts. But the police do not always need a warrant to seize evidence or arrest persons. When police make a lawful arrest, they do not need a warrant to search a suspect for a weapon, since that person could possibly use that weapon to assault a police officer. So you don't need a warrant in that situation. Now, if the evidence is in plain view, a warrant is also not necessary. So like if a police officer sees an illegal action through an open window, they can just act right then. They don't have to stop and go find a judge. Also, vehicles, meaning things like automobiles, boats, or airplanes, these can actually be searched when there is likely to be probable cause, since this is considered to be a movable scene of crime. But generally speaking, otherwise you're probably going to need that search warrant. Now, while police must have probable cause to conduct searches and seizures, schools only require reasonable suspicion, which is a lowered legal standard, in order to conduct searches and seizures. And this was actually reinforced by the New Jersey versus TLO 1985 case. Now, the Fifth and 14th Amendments guarantees the government cannot deprive people of life, liberty, or property without due process of law, meaning that they must act fairly and in accord with established rules in all that it does. Now, due process governs police power, which is the authority of each state to act to protect and promote the public health, safety, morals, and general welfare. Now, police officers may only sidestep a person's due process if there are reasonable grounds to do so. For instance, if you have someone you suspect of being a drunk driver and they refuse to submit to a blood test, then they could possibly sidestep their due process. Also, police officers may not use unnecessary force. So as they enforce a criminal law, you can't use more force than is necessary. Now, the constitutional guarantees of due process have created a right of privacy, with Roe v. Wade of 1973 being a landmark case in providing medical privacy rights. The court ruled in a 7-2 decision that the decision to have an abortion was a private matter between a woman and her doctor. Now, abortions could not actually be restricted during the first trimester, but they could be restricted when the fetus reached what they called a point of viability. So usually a fetus is considered to be viable somewhere around 28 weeks or 7 months, but possibly as early as 24 weeks. So generally speaking, this court decision more or less said you don't really have rights as a human until you are at a point of development that you could live outside of the womb, is more or less what was said. Now, the Fifth Amendment guarantees a right against self-incrimination, which is the right not to be forced to be a witness against oneself. This right guarantees that the burden of proof is always on the prosecution. Also, the Fifth Amendment self-incrimination cannot be invoked when testifying against someone else and when your testimony could not lead to a criminal charge. So if you feel like, well, I don't want to tell on this person, that's not actually protected based on the Fifth Amendment. Again, if it's against someone else. Now, it is also up to the courts to decide when this right of self-incrimination is actually allowed to be properly invoked. So you actually have to get permission from a judge before you can plead the fifth. In Miranda versus Arizona of 1966, the court determined in a 5-4 decision that accused must be informed of the following rights at the time of their arrest. And if you've ever watched a television show that had anything to do with police officers, you probably heard this before. You have a right to remain silent. Anything that they say can be used against them in court. They have the right to have an attorney present during questioning. If they cannot afford an attorney, one will be provided at public expense, and they may bring police questioning to an end at any time. So generally speaking, if a police officer doesn't read you these rights, then any of the information they might have developed against you is not legally allowed to be used in court. Also, the Fifth Amendment guarantees a grand jury, which is a formal device by which a person can be accused of a serious federal crime, not state crimes, but federal crimes, although most states do have grand juries, and also protection against double jeopardy, which means that once a person has been tried for a crime, they cannot be tried again for the same crime. Other countries actually don't have this protection, so you could actually be tried multiple times before you actually have a final say. Now, the Sixth Amendment guarantees the accused rights during the trial process. So after you've been charged, but during the actual trial. Now, the Sixth Amendment guarantees a speedy and public trial by an impartial jury. A speedy trial ensures that the government will try a person accused of a crime without undue delay. Now, there can be valid reasons for a delay that aren't actually a violation, but it's just so you don't have to worry about spending years and years and years waiting for your trial to take place. Now, a judge can actually limit the number and kinds of spectators that are present at a trial. If they feel like it's not to the benefit of the accused, they can actually ban the media from attending a trial. Now, jury trial is only guaranteed in cases of what are serious crimes and can be waived by the defendant. So a defendant can actually determine that they don't want there to actually be a jury and they want a bench trial. Now, a defendant also has a right to be informed of what they're being accused of, confront and question witnesses that are against them, or have witnesses that can be questioned in their defense, and also have the assistance of an attorney, even if they cannot afford an attorney. Speaking of, in Gideon versus Wainwright of 1963, the court determined in a 9-0 decision that the right to an attorney actually extended to state felony cases, even if defendants were unable to afford their own. So in this particular instance, you had Gideon, which was picked up for a crime. I think might have been a robbery and murder, but it was at least a robbery. And he asked for a lawyer at the time, and they basically said, you don't get a lawyer because this is a state crime, this isn't a federal crime. Then went to prison, and then basically researched the law himself, and then eventually got heard by the Supreme Court, which said that, yeah, you do have a right to a lawyer, even if it's a state felony case and not a federal one. Now, the Eighth Amendment provides protections against certain types of punishments. It protects against excessive bail and also fines. Now, bail is usually set in accordance with the severity of the crime. So the more severe the crime you're being held for, usually the higher the bail. Now, it should be pointed out that a suspect can be held without bail, but there must be good reason to do so. So, for instance, if there's a high likelihood of a person being a flight risk or likely to commit another crime, they can not have bail, which is known as preventative detention. Now, Eighth Amendment, it also forbids cruel and unusual punishment, which prevents very barbaric tortures, things like burning at the stake and crucifixion. Yet, the Supreme Court has deemed that capital punishment, which means punishment by death, is constitutional, as long as that punishment is a part of what's called a well-drawn two-stage law, meaning they have to have a trial first, followed by a sentencing hearing. Also, all prisoners, even those that are sentenced to death, cannot actually be denied medical care, which might lead some people to question, why do regular citizens not have a right to medical care, but convicted felons do? All right, that concludes Civil Liberties and Civil Rights, Section B lecture. Our prioritized standard was Government Civics 25, and objectively now you can evaluate the balance between due process protections and government restrictions against it.